I'll make a start. It's 10 o'clock, so we will start. So thank you everyone for joining us. I think we've still got some people joining, but we'll start anyway because I think we've got quite a lot to get through. So um, firstly, my name is Angela Wood and I am the Managing Director of ETC Tax. I'm also a Chartered Tax Advisor, so I think a few of you will know me, but not all of you. So um, welcome today. And Sean, I know you've got control of the slides, so I'll let you introduce yourself, but also if you flip to the next screen, I think there is a lovely photo of us both on the next screen, if you like. There we go. So Sean, do you want to just introduce yourself?
Thanks, Angela. I'm Sean Randall. I'm an independent stamp duty advisor. And Angela, you've kindly asked me to speak about stamp duty for the next half an hour or so.
I have indeed, yes. So Sean and I have known each other for a few years now, and Sean, we work together, don't we? And where Sean provides specialist input on stamp duty land tax matters, we as a firm obviously advise on property tax matters, but the SDLT stuff can and often does become very complex. So always good to defer to an expert like Sean. So I think Sean, we'll hand straight over to you, and you can get going with today's agenda if you like, then, please.
Okay, great. Thanks, Angela. Um, what I thought would be helpful is if we talk about some topical issues, some recent issues. Life is always changing in the world of SDLT. Um, Then I think after we've done that, there'll be some opportunity for questions. And I think, Angela, you wanted to speak to a few issues that you see, particularly in the world of property at the moment.
Yeah. Just at the end, I'll just do a sort of roundup of some of the things that we're seeing generally in property. Just about only 5 minutes. That's great.
Cool.
Thanks.
Good. Okay. So in terms of stamp duty, I'll talk to multiple dwellings. It's still relatively important, although now that multiple dwellings relief has ended, perhaps it's less important than it was. But so we'll cover that to some extent. We'll cover, I think, an interesting case, which was a reclaim of stamp duty, but it actually resulted in more tax to pay. So there's a salutary lesson there in stamp duty, which, as I say, we'll cover briefly. Then mixed use, and in particular the meaning of grounds, which is an important issue for stamp duty because it really affects the level of stamp duty or the amount of stamp duty to pay in some circumstances. Then derelict dwellings, very topical. And then three cases which are relatively recent, all in the last, I would say, 6 months, a couple only in the last 4 weeks, really. And they produce, I think, some surprising results. So they're important things to understand. Okay, so the main theme for this, if it's not obvious, is classification. So in other words, how do you classify a property before you buy it? Is it residential? Is it non-residential? Is it mixed use? And the reason why that matters is because there's a huge difference now in the rates of stamp duty. Top rate of stamp duty for non-residential or mixed use transactions is only 5%, whereas the top rate for residential transactions is a whopping 19%. Okay, so that adds a little bit more color. So these are updates and there's 4 case studies. Okay, let's look at multiple dwellings. So been lots of appeals. Goodness, maybe 15 or so, I think, maybe slightly more even. They all relate to whether a second building or part of a building is suitable for use as a single dwelling. And if it is, in the past, a partial relief was available called multiple dwellings relief. And that ended last year in June. It was worth for a single annex that qualified for this relief. It was worth up to, around about £90,000, as I recall, 87,250. Lots of appeals have looked at in what circumstances something is suitable for use as a single dwelling, and those appeals are actually still continuing, reflecting the kind of drag in terms of a dispute resulting in a tribunal hearing. But it's still relevant, even though the relief has ended, because until mid-June this year, it's still theoretically possible to reclaim stamp duty by claiming the relief retrospectively. And you need to do that. You need to claim to get this relief retrospectively by applying within 1 year and 14 days of the completion date. But it's also relevant too to higher rates, and this is something that is less good news, of course, which means that even if you don't own any other dwelling at the completion date, if you're buying two dwellings in one transaction, well, then that automatically engages this now 5% surcharge, unless one of these dwellings is subsidiary. So identifying whether you have two dwellings or one actually can result in more tax to pay, subject to meeting this exception for subsidiary dwellings. Also, it's relevant to a particular rule that says where you buy 6 dwellings in one transaction or 6 or more dwellings in one transaction, well, that's also regarded as non-residential. Even if it's exclusively residential dwellings, if you buy 6 units, they're deemed to be commercial for this purpose. And it may be that there are some buildings that might be used as HMOs, but nevertheless are suitable to be used as 6 separate dwellings. There may be a very large country property with staff accommodation and guest suites, which collectively might, go up to 6 dwellings. So understanding whether, as I say, a building or part of a building is a single dwelling is still relevant. And remember too that in Scotland and Wales, they have their own multiple dwellings relief still. I'm not sure how many of the audience advise or buy land in Scotland and Wales, presumably a few. And so do bear in mind that this relief is still available in those regimes, albeit in Wales, there are draft regulations which, when passed, will mean that if something qualifies for the exception to the higher rates because it's subsidiary, well, then it won't qualify for this relief, multiple dwellings relief. So there's a particular change happening for Welsh multiple dwellings relief. Okay. And I wasn't going to go over all the cases, not least because there are many of them. But it's worth understanding that although the revenue have been successful in the majority of cases, for sure, there have been recent cases, I can think of 4, which I put on this slide, where the taxpayer was successful. And I think it's fair to say that in the course of inquiries and disputes, the revenue have, over the last sort of year, increasingly placed emphasis on the extent to which a dwelling, or arguably a dwelling, provides privacy and security. And they were taking quite a bullish approach in saying that if something is situated near to a main house, if it's overlooked by a main house, particularly if it's in a country setting, well then privacy and security would be compromised and therefore it wouldn't qualify. And these cases, Yeoman, Packman, Winfield, and so on, all say that privacy and security, although they're certainly relevant and necessary, they're not absolute factors, they're not absolute requirements. And actually the leading case, which is an upper tribunal case, says you just need a degree of privacy and security consistent with a dwelling. So arguments that have been made by the revenue that something doesn't qualify because it has a shared garden or it doesn't have a garden, or to access it you have to walk around, the front of the house and you can look into a house. Those arguments haven't really been met sympathetically by the tribunal in some of those cases. So some level of intrusion, the courts have said, will be tolerated. Okay, I'm expecting you, Angela, to comment occasionally.
Well, I was about to comment, but I didn't know if there was a pause there actually. And I was just about to echo what you've said actually, because we obviously over the years we've looked at lots of cases of multiple dwellings relief, and this point about privacy was a really interesting sort of step change. I think we started to see quite a lot of knockback from HMRC on sort of this privacy issue, which was was a change, I think, and some of it quite quite OTT, I'd say, with well actually where you've got I don't know, an annex that is a genuine separate dwelling, as you say, but it's down at the back end of someone's garden, but or it's the front end of someone's garden, but you have to walk past it to get to the main house. HMRC's arguments were, quite interesting on some of that, I think. So
Yeah, it's good.
agreed.
Thanks.
No, no worries.
Um, yeah, and in one of those cases, which is very recent, in fact, Charlie Johnson, it was only published, I think certainly this year it was published, although the case was heard last year. There was an interconnecting door, but it didn't have any locks, and that's certainly been an issue that the revenue have looked at and argued on the absence of interconnecting or devices on the doors at completion, which prevents people accessing each part of the property. And here there wasn't. And yet still the taxpayer won because they argued that it was possible to fit a particular device called a door brace, which seems to be, a stick which attaches to the handle, I think, which does effectively provides privacy and security to both parts because it is impossible once that door brace is fitted to both sides, neither person can unilaterally open the door.
Yeah, and if I can just add to that, Sean, again, a case that we
Yeah.
had, one of our clients, it was an Airbnb she was operating as the sort of separate dwelling, but it had a huge, and I've seen the photos, and I mean huge Welsh dresser, because the property was interconnecting, but there was a Welsh dress on one side to stop you walking between the two properties, which had, the separate property had its own kitchen, etc., fully functional. But HMRC again quite bullish on that in terms of this locking door point, which I know we've seen before in the past, haven't we?
Yeah, and ironically, the revenue did say in their guidance manual, it's still there, that if devices could be fitted readily, easily, I think, then they would accept. So they
Mm,
have argued perhaps inconsistently with their own guidance on this point
I
in the
agree.
past.
I agree. Who would have thought HMRC would be inconsistent with itself, though? Moving on.
Okay, so um, this is a particularly interesting case, and I think it's worth pausing to look at it. So it's a case called Goldsmith, again published last year, and I don't know when I've reached the end of the bullet points. I think I have. Yep. So I'll go back. So here, it all looks very benign, very standard, which was that an individual exchanged contracts to buy a property intending to develop it into three flats. They had experience of this before. I think it was in London, relatively expensive property. But between exchange and completion, the individual found a mortgage product which was better, but was predicated on the buyer being a company. So perhaps unsurprisingly, the individual assigned the contract as he was permitted to do under the contract. He assigned it to the company, which was probably held by him or controlled by him, to get that better mortgaging product at completion. The other twist is that before completion, perhaps having taken some advice, the company successfully sought permission to access the property to start the conversion process. I think the permission was actually based on doing some pretty minor works and inspections and so on. But in contrast, in fact, the company did some pretty major physical works to begin and start the conversion process in earnest, apparently in contravention of the consent. Anyway, the company paid stamp duty at the higher rates, 132,000, and then after completion, they were approached by a firm, I think, to make a reclaim on the basis that the building at completion was in the process of being adapted for use as three dwellings. The revenue didn't like that argument. They challenged it and they lost. And the company was successful, therefore, in making that repayment, or that reclaim rather, and getting £46,000 back by virtue of getting MDR. The revenue also said that the company had substantially performed the contract, which meant that they would have paid stamp duty or been liable to pay stamp duty when they took access or took possession of the property. And the tribunal's reasoning perhaps wasn't as clear and full as it might have been, but they placed emphasis on the fact that the the access wasn't in compliance with the permission. And there were some conditions attached to the access permission, such as, collecting the keys each day and giving them back each day, which meant that, in the tribunal's view, possession wasn't taken. So the revenue lost the challenge on multiple dwellings relief. They lost on challenging the point about substantial performance. All good so far. However, what the revenue did see in the context of the inquiry was that the individual had assigned the contract. Now, for those who are familiar with stamp duty, and you need to be pretty familiar to understand this point or to be aware of it, is that when someone assigns a contract and then the contract is subsequently completed, the assignor, here the individual, also has an SDLT charge. So the completion of the contract after it's been assigned gives rise to two SDLT transactions. One in the real world, the acquisition of the property by the company here, and one in the SDLT world, which is a notional acquisition by the individual. Now, relief is available to prevent a double charge. So the individual could and should have made a return to claim what's called sub-sale relief, if you like, or relief for pre-completion transactions, but didn't know. And they were too late to do so. So the revenue imposed another 132,000 on, for the individual. So there was a double charge to SDLT. And although, claiming the relief didn't, cause that tax to be paid, it was always payable. It certainly resulted in the revenue finding out that it was payable. So the £46,000 was dwarfed by the extra tax that was payable by the individual. So important lesson there, that whenever you act for someone that is assigning a contract, subselling property, novating a contract perhaps, whenever something is happening between exchange and completion, it's worth understanding the SDLT treatment. You're on mute, Angela.
Sorry, I think we've got a few lawyers on the call today, as you might expect. And I know that when I was in practice as a lawyer, albeit not a property lawyer, the advice to the property team, the property lawyers was always, if there's anything a bit different, seek specialist advice. And I think the Solicitors Regulation Authority have also advised that that's really important, actually.
Yeah. So it's a real shame for the individual.
Yeah.
The tribunal did comment saying it was a pretty punchy thing to do by the revenue, but
Yeah, it's quite ballsy, isn't it?
yeah. Okay. All right. Let's move on. Grounds. So here, the context isn't multiple dwellings relief. The context here is mixed use. So we're here, just for those who aren't aware, we have a particular hard-edged rule, all or nothing, which says, to any extent, if you buy property that isn't residential, in inverted commas, then the whole of the price is taxed at the non-residential or mixed rates, which is top rate of 5%. So there's no de minimis rule in terms of ensuring that the proportion of the price attributable to the non-residential exceeds a particular threshold. There's no apportionment rule, meaning that the price isn't apportioned between the part that's attributable to the residential and that's taxed at the residential rates. It's all or nothing. As soon as you have some non-residential, then the mixed use rule applies. And in this context, in the context of like a country property, perhaps, the argument is that if extra land or if land is purchased with a house and it isn't part of the grounds of the house, well then by definition it's mixed use because it's no longer residential. Here there've been even more cases, as you might imagine, in respect of this issue, understanding in what circumstances adjoining land or land adjoining a dwelling constitutes grounds, and the revenue have won every single case apart from four. And one point perhaps to, take away, I'm not sure what relevance it has perhaps for many people, but the wins have been taxpayer wins. So well, for the most part, they've been litigants in person. I think there's been one exception to that. So it's easier. It's easier to win if you don't instruct an advocate. It seems. But the bar is super high. And a particular case I was involved in last year, I think, is an example of that. So here we have an individual that bought a expensive property. There were 120 acres, but 40 of those 120 were used exclusively by quite a large professional farmer for the production of hay. So the farmer had the right to grow and remove two crops of grass each year, which was relatively material in cost, or both to him, the farmer, in removing the grass for hay. I think it cost between £5,000 and £10,000 each year in terms of fertilizer and using machinery and so on. But the hay was worth, 4 times that, I think. So it was profitable to remove the grass for hay, and this was pursuant to a formal license granted each year, I think for more than 7 years, which imposed restrictions on the owner of the land, not interfering with the right of the farmer in growing and removing the grass. So the owner didn't have permission to, though they used the land and they remained entitled to possession of the land, they couldn't, put their own livestock on the land or do any events which would, stem or, prevent the grass from growing to the required extent. And the tribunal wasn't sympathetic to that argument. They did think that in spite of this use, which was obviously non-contrived and which was formal, it wasn't a barter of convenience. Money was paid by the farmer for this permission. That nevertheless, with those 40 acres were grounds of the house.
Right. I'm saying why, Sean, because I wasn't aware of this case, and I think that like you said, that's really very interesting, isn't it? I mean, mixed use, I think, is really problematic, isn't it? And the way that I'd always viewed this was whether you've got, say, some clear documentation, you've got restrictions, you've got some clear commercial use. That for me would have been a mixed use property. So where do you think this will go then?
Well, I'm spinning it slightly. The land was adjoining. It was partially visible from the house. Um, But I think it's surprising, and I use it
Mm,
as an example to indicate that this is a difficult area to be successful on.
yeah,
The other point is it's very, very subjective, and so
yeah,
the trouble with multiple dwellings relief, and as we'll see on derelict dwellings and mixed use cases, it's very sensitive to lots of factors, and then you have to apply what you think the right level of weight is to each factor, and your opinion on what that weight should be is different to mine. Um,
yeah.
it's very difficult also to apply principles from these cases to other cases that have different facts.
Mm.
So the whole thing is really clouded in uncertainty and subjectivity. But yeah, I think this particular decision was surprising.
Yeah, I mean we've had clients in the past, with with horses, paddocks, a few sheep on a bit of land, and that's and again I think because of the way that some of the SDLT reclaim companies have gone as well, that the client's being told that actually they should be looking at mixed use claims, whereas you kind of think not sure, but yeah, it's surprising this, isn't it?
Yeah.
Mm.
Okay. Uh, let's move on to derelict dwellings. So the context here is that there was a case, now probably 6, 7 years ago, where a company bought a bungalow in Weston-super-Mare to demolish and rebuild. So it wasn't economically viable to renovate the property. It was really in a bad state, had no copper pipes. Um, I think floorboards were missing in parts, had lots of asbestos, which would inevitably be exposed during the course of any renovation. And it wasn't worth very much, if I'm being honest, the particular bungalow. So although it might have been cost effective to renovate perhaps in London, in Weston-super-Mare, I don't think it was. Um, and the company paid tax at the standard rates. The revenue said, oh, that's wrong. They should have paid tax at the higher rates, which are the default for purchases by companies. And the tribunal said, you're both wrong. Actually, you should have paid tax at the non-residential rates because it wasn't suitable for use. Now, off the back of that, there's been a very large reclaim industry inviting people to reclaim stamp duty paid on dwellings if at the time of completion they were suffering from damp, mold, water ingress, broken roofs, broken tiles and windows and things. And it's fair to say that that reclaim industry were really pushing the boundaries. And since that first case, there have been three others which have shown that you really need to go some in order to show that something isn't suitable for use as a dwelling. And it's very clear that suitable for use, although those words perhaps might invite someone to think that that means ready for immediate occupation, the tribunal has been super clear that it doesn't mean that. It doesn't mean habitable. So you absolutely need to show that it's objectively uninhabitable, but that's not itself enough. And these cases have shown that really, in order to have any argument, you need to show that it's uninhabitable for a particular reason, reasons which can't easily be fixed by um, general repair. So you need to show that something is structurally unsound, or perhaps there's hazardous material like asbestos, and then, even then, you may not have enough. So this has all been borne out in particular by decision of the upper tribunal. So before, we've looked for the most part at decisions of the first tier tribunal. Here, though, Mudan last year, we've got an upper tribunal decision, which is akin to the High Court, and which is being appealed, I should say. I think it's being appealed in the autumn this year to the Court of Appeal. But so far, the decision of the upper tribunal is effectively what I said, that if a building is not habitable but it's structurally sound, I don't know if you've got some noise, Angela. I keep hearing something. Don't worry.
I think
Don't worry. Okay. So the upper tribunal said that even if it's not habitable, as was the case in Mudan, it been vandalized at completion by the tenants who were evicted. So even though it was not habitable at completion, if the building is structurally sound, it would be taxed as if it were a dwelling because it's still suitable for use. So the particular building in Mudan needed complete rewiring, a new boiler, had leaking pipes, broken windows, locks. The whole kitchen had to be removed and put back. But I think it had some pretty nasty problems with rats or something. Um, and yeah, the upper tribunal upheld the decision of the first tier tribunal that that suitable for use does not mean ready for immediate occupation. And they've gone on to say that its previous use as a dwelling is relevant. And does it retain its fundamental characteristics of a dwelling? So we're going back to, like MDR and mixed use, we're going to another multifactorial test. You look at lots of different factors, including how it was used, what the defects are that prevent it from being occupied. Can those defects be remedied easily? Do they affect the structure of the building? Is it dangerous to occupy? All those things must be taken into the round. And so I think some reclaim firms that are making those kind of arguments that mold, damp, water ingress, some pretty common defects, there's definitely not going to be enough going forwards.
yeah, and again, we've seen lots of examples of this, and because we tend to be on the receiving end of clients when they're coming saying, I've spoken to a firm and they say I can make a claim here, and as you say, it's a high bar.
Yeah, it's getting even higher, I think.
Yeah.
However, what's not clear is whether dwellings which are partially renovated, perhaps sold at something called shell and core stage, where clearly there's no utilities, no kitchen, no bathroom, sometimes no internal walls and so on, whether they are still suitable for use. That's not the same as something which is derelict, damaged, dilapidated. That's something that had started to be renovated but is no longer being renovated. Or what about a dwelling which is partially demolished and perhaps which is intended to be demolished? So we haven't yet had cases which have looked at those two issues. And I think there may be a distinction there between the earlier cases like Mudan on derelict and these types of cases. Okay, Angela, what is that building?
It's like a
Is it a
nice,
house? Is it an office?
looks like a nice country house to me, Sean. But
Oh, that's the wrong answer, Angela. So,
there you go.
so this is a decision, recent decision. Oh, the transition's a bit odd here. Hold on, bear with me. Okay, so a case in Scotland, although it doesn't matter because the rules are exactly the same on this particular point. So it's Scottish SDLT, but don't don't pay much relevance to that. It's still completely analogous to SDLT in England and Northern Ireland. So this building was built in the 17th century, 1662, of some importance actually, and used as a dwelling as such until 1980. So for 300 years or so, it was a single house, as you say, Angela. Yeah. But then it was converted to an office, and I think it was the headquarters of quite a large firm, and used as offices for what, almost 30 years.
Mm,
Then the occupant moved out, and the dwelling started to fall into disrepair, and it was sold. But when it was converted, I put it in emphasis that it was converted. So some pretty substantial works had been done to enable it to be used as offices. And in particular, the kitchen and bathrooms weren't domestic, they were designed for office use. And then this building was marketed as use, as in use as offices, but clearly, as you would expect, the agent said that it had the potential for a range of uses. And then before completion, the buyer sought planning permission for consent for change of use in order to use it as residential. So those are the kind of facts. But the important thing is it was used for 30 years as an office. That was its last use. It still had um, uh, business rates and so on, and still had lots of office fixtures. But the Revenue Scotland, so HMRC's equivalent in Scotland, successfully argued that it was a dwelling, despite all of that. And they relied on that decision I mentioned before, Mudan, which looked at the essential characteristics and nature of the building. And I think the tribunal, reading between the lines, were swayed by the comparatively short time that it was used as offices, so 30-ish years compared to 300, and also the very short time that was estimated to reverse those office fixtures and remove them was only a couple of months. In the end, I think it took longer, but that was attributable to a leaking ceiling, I think. Anyway,
mm,
it wasn't very difficult to convert it back into residential property, and obviously it had been used for much longer as residential than commercial. But I would say, in looking at that in the round, applying the multifactorial test, that a building's last use is more informative or instructive than its, use 300 years ago.
yeah,
So
great.
I thought this was a surprising answer.
Yeah, okay. Sorry to interrupt, and I completely agree. And as is often the case, there's some interesting VAT angles to this as well, isn't there? VAT and SDLT often come in hand in terms of what that last use that building was put to, and what the VAT position would be then on a conversion of that. So yeah, it's a surprising decision again, isn't it?
Yeah. So don't let your intuition get the better of you in the sense that, if you buy a building that was last used or is even in use at completion, as we'll see, for non-residential purposes, it isn't necessarily going to be agreed by the revenue or the courts that it's non-residential. So let's look at this one now. Angela, you've got them all right so far. What's this?
Oh, wrong, don't you mean? Well, I was going to catch me out now. See, I would say that looks like an office, but you're going to tell me it's not an office, clearly, but that looks like an office to me.
Well, I'm going to say it's a bacon smoking factory,
Okay.
obviously. So
Obviously.
this was a case reported in the Times recently. Um, it's a Russian financier who bought what was a bacon smoking factory for 6 million. And obviously the upstairs or the upper part had been converted into a wonderful house. But the ground floor was in use at completion for commercial purposes. Come back to that, but it was in
Mm.
use. No planning permission for residential use. The ground floor retained its planning classification as light industrial use only. Um, the ground floor was business rated and it had its own non-domestic EPC. And also in the sale contract, standard commercial conditions of sale were used. So those are all the kind of arguments made, as you might imagine, by the taxpayer in saying that he had bought a property that was mixed use. And superficially, that's pretty, I think, compelling, particularly the fact that it was in use, not as bacon smoking, but it was in use for commercial purposes at completion. And again, the reason why I'm saying this is because the tribunal found, perhaps unsurprisingly, that it was entirely suitable for use as a dwelling. Um, and the reason for that uh, is that the issues perhaps weren't as clear and robust as perhaps you would expect. So, although the ground floor only had permission for light industrial, in fact, part of it had been converted into a bar. I think it
Mm.
was intended by the owner to be part of a gin district, gin distillery business, but in the end, he decided not to pursue that. Um, but it was also a games area. So part of the ground floor had been used and was suitable for use as hospitality in connection with the main house upstairs.
Lost your sound there, Sean. I don't know why. You're not muted, I don't think.
Can you hear me now?
We can. Yeah, good, you're back.
Good. Right, it switched to a different microphone. Um, but the ground floor wasn't separated, so it wasn't a classic mixed-use property in the sense that the upper part had an external staircase. You could go through internally up the staircase from the ground floor to the main part of the house. No adaptations were needed to begin using it as a garage, also the ground floor. So the commercial use at completion was really storage of
Mm.
stock of the trade of the owner's wife. So the wife ran a recycling business or upcycling business, stored some of the products that she was selling on part of the ground floor. So really, it wasn't very difficult to remove that and begin using it as a garage or personal storage. And there was a lot of emphasis in its suitability as a whole house in the marketing, as you might expect. And that commercial use, by virtue of the fact that the occupier of the commercial use was the wife of the owner, there wasn't any kind of formal contract or tenancy or license. So the facts weren't strong
Mm.
once you looked into it in more detail. But the tribunal did make some pretty punchy comments to say that last use or current use at completion, which is non-residential, isn't determinative.
Mm.
Uh, and also those planning restrictions are relevant but not decisive. The Revenue have in their manual the example of a dentist uh, surgery which is located in a residential property, and if it was sold, they would accept that that isn't residential because in order to convert it back into a residential property, some physical adaptations would be needed, such as removing all the lead from the walls, which were installed in connection with X-ray machines. So if you need to physically adapt the building in some way to make it suitable for residential, I think the Revenue would accept, that it's mixed use or non-residential. That wasn't the case here.
Hmm. It makes a bit more sense, that case, doesn't it? But not much still.
Yeah. Um, and finally, we've got this. What's that, Angela?
I don't know, because I keep getting them wrong, don't I? I'm gonna go house with this one.
It is, well, who
Dwelling.
knows? So this one is,
Who knows?
so this one was an earlier case, but still last year. And
Hmm.
as you can see, it was a lovely listed old manor house. And both parties, the revenue and the taxpayer, accepted that it was suitable for use as a dwelling. Uh, the taxpayer had paid tax at the non-residential rates, arguing that it was mixed use. The revenue argued um, that it was residential only. And I should have said that the last owner, the seller, had used it as some form of bed and breakfast.
Hmm.
So the appellant argued, well, look, it's a hotel or similar to a hotel, and the particular classification or words used, I think both for stamp duty and VAT is hotel, inn, or similar establishments. If you can show that a building is used at completion as a hotel, inn, or similar establishment, then it's non-residential for stamp duty. And there's a, as you say, Angela, there's a very big overlap for VAT with all of this, but particularly for this. Um, and perhaps unsurprisingly, the tribunal, when they looked at this, found that such an entity, such a classification, a hotel, inn, or similar establishment, means a trade including the provision of sleeping accommodation to paying guests with additional services of some type. So nothing really surprising there. Uh, and the tribunal looked at all the facts, and as we'll see, the appellant did just enough, which is surprising because the facts were pretty strong. So the seller had intended to run a B&B. That's why she bought this property. Um, sorry, that's why the seller, bought the property. It had done some physical works, um, including installing a commercial kitchen as well as commercial fire alarm. It was suitable for use by three paying groups of guests at any time. It had been used, perhaps not continuously, but it had been used extensively for paying guests. There was its own domain name, and there were 27 online reviews for the property. And the seller had employed cleaning staff, and the properties or the bedrooms rather were cleaned every day. There was also gardening staff. So the facts were strong, but on the other side, there weren't food safety ratings. It wasn't business rated. The seller didn't seem to be VAT registered. And looking at it in the round, the tribunal said there was just enough by the finest of margins. It was a hotel, inn, or similar establishment. And the surprise there, I think, the takeaway is, wow, if that only just got through and it was very peculiar to the facts of this particular case, well, many properties that are used in connection with a bed and breakfast trade might not be non-residential.
Absolutely.
Okay, before we open up to questions, and perhaps we'll look at a few other issues that you've seen, Angela, I just wanted to leave you with some takeaways, some warnings or conclusions, which is classification is uncertain, still developing in the courts, still expecting more cases on all the things that we mentioned, or looked at rather, multiple dwellings, mixed use, derelict dwellings, all of those, I think, will be the subject of cases this year. The revenue are not infallible. They do lose. And there've been more losses for the revenue last year than I think there's ever been since all these issues started emerging. And I think that's because they're starting to get to more difficult facts where the issues are more complicated. But the overriding takeaway is to proactively assemble the evidence in advance of an inquiry. I mean, it really is obvious and it goes without saying, but um, it's much easier to satisfy the revenue with evidence if you collect it at completion rather than 9 months later.
Yeah.
So assembling
statements of truth, witness statements, in other words, and other contemporaneous evidence, how it's been marketed and so on. Um, and collecting that in case there's an inquiry is really good practice.
Good.
I don't know whether you want to talk to your bits now, Angela, or whether we go straight to questions. Should we talk?
Yeah, I think. Yeah, well, maybe. I mean, we've got a couple of questions. By the way, in case the attendees aren't aware, if you have got questions, do pop them in the Q&A, the chat box, and we'll pick them up from there. I've got two or three already, Sean. I'll just do this slide, I think, briefly. This was really just to sort of join things up, I suppose. Sean, if you don't mind just uh, pressing it once more, hopefully the rest of the bullets will appear. There we go. That's right. I think there's one more on there as well,
Oh,
actually. So don't know what's going on. Like you say, some of these transitions are a bit odd. Anyway,
sorry.
that's there we go. So, I mean, it was really just to join it up. So, obviously, thanks, Sean, for that. We'll come on to questions in a minute, but SDLT specific or more general questions if you've got them. And yeah, really, really interesting the direction of travel there. I mean, as I say, as a firm, we work with Sean to provide that expert input on SDLT. But obviously, as a firm, we do advise on property tax matters day in, day out. And I just wanted to kind of give a flavour of some of the things we've been working on recently in property. I know that the attendees that are here today are interested in property tax matters, hence they're here. So just it's what it says there on the slide. But I'm not going to go through this in any detail. But we've recently done some CGT advice for a client who was disposing of property which had been the subject of a CPO to do with Crossrail in London. I've had a few CPO cases along the way actually. So again, there are some sort of nuances around that, some sort of specific points of interest. So just to be aware of really. So if you've got something like that, or you have clients, or you find yourself with the CPO position, that's something we can assist with. Private residence relief, which again, a bit like SDLT, actually, people always think, well, that's quite straightforward, isn't it? Not always, I'd say. We've done some really quite complex work with private residence relief recently, where kind of I started to regret taking on the clients, actually, because it became very detailed and very complex, and inheritances and all sorts of crazy stuff and gifts and how that relates to private residence relief. So that's been quite interesting. Landlords always big, lots of conversations with landlords, particularly around IHT at the moment. The trend was to talk to landlords about the mortgage interest relief changes which occurred between 2017 and 2021, which we are still talking to landlords about. But I think increasingly now landlords are very interested in their inheritance tax position. They find themselves with a lot of property. And a lot of wealth and value associated with that property, and then wondering what to do about that from an IHT point of view. So we're doing a lot of that at the moment. We've already mentioned VAT on this particular one related to a conversion of a derelict factory into residential dwellings. So Sean, definitely some SDLT challenges and VAT challenges when we're thinking about anything where there is a change of use, I think, or there has been a change as you've talked about during the course of your presentation. So this was a VAT specific problem, but with SDLT elements. Again, structuring advice for individuals involved in both property investment and property development. So we often find, Sean, I'm sure you have as well. So people that work in and around property, clients that have property, they're often involved, not always, sometimes they're exclusively involved in investments, sometimes they're into development, sometimes they do a bit of both. We sometimes find that clients sort of try to do that in one vehicle, for example, and we'd always encourage a separation across different companies where there's a development aspect and an investment aspect. So structuring clients' affairs around that has been a big part of what we've been doing recently. And then the last one on there is just advice relating to clients that find themselves involved with the non-resident landlord scheme and the annual tax on envelope dwellings. So lots of people approaching us recently who hold property in the UK but who are based overseas. So we've done quite a lot with that recently. So I just thought I'd give a flavour of some of the things that we've been working on here as well, more generally. So thanks for that, Sean. So we'll take some questions. Sarah, I know you're still hovering around. I can deal with the ones in the chat and a couple of the ones from earlier if you like, Sarah. So I may as well deal with that whilst I'm here. Normally Sarah is our host, but I will sort
Okay,
of
no
do this.
problem.
Save you a job, Sarah. So the first question, Sean, these are for you, SDLT specific, as you might expect. So if you are buying a part-built residential site for a developer, would it be commercial SDLT rates or residential SDLT rates? I think we touched on this idea you did about, these cases that perhaps haven't been tested, but do you have a view on that, Sean?
I think if it's intended to be converted into six or more dwellings, either way, it's going to be commercial. So we've got that rule that says buying six dwellings in one transaction is non-residential under a deeming rule. So if a building is in the process of being converted into six, then that rule would apply. And if it's not in the process, well, then it's not residential in the first place. So either way, however you cut it, it's going to be non-residential if there are 6 units intended to be converted or developed. If you've got fewer than 6, well, then it's very difficult to know for sure. And I think that depends on things like um, when the building ceased to be developed, when those works ended, and at what stage those works had reached. So you're getting into some quite fact-specific issues,
Yes.
which will, I think, sway whether there's a legitimate filing position to say that it's non-residential, or whether in fact it's pretty obvious that it's in the process or readily capable of being finished into converted units.
Yeah, that makes sense. Yeah, and as you say, it's as with a lot of these things, it's very fact specific, isn't it? So as I often say, I'd always encourage special advice from someone like yourself, Sean, if that's in any doubt. So yeah, thank you for that one. And now this one looks quite complex, but perhaps isn't. So someone said, please could I ask how non-resident SDLT impacts UK residents purchasing a primary residence when they spend the majority of the year outside the UK travelling? So I think this is someone just buying a main residence, the main dwelling, their home in the UK, whilst non-resident. Is that how you read that? I think that's how I read that.
Yeah, so the temptation is to say that this surcharge for non-residents, which is 2 percentage points, is sensitive to nationality, domicile, settled status, intention. None of that matters. So either you pay the surcharge or you don't, depending on how many days you've been physically present in the UK in the 1 year before completion. If you get up to 183, then you don't pay it. If you don't get up to 183, you do pay it. But the circumstances for why you were present in the UK or absent from the UK, totally irrelevant. There's no kind of extenuating factors or discretion. Um, uh, so if you do have to pay it because, let's say, work prevented you from staying in the UK for more than 183 days, or for at least 183 days, so you have to pay it, even though your nationality is British and you intend to reside here once your work contract is ended or whatever. Nevertheless, you do have to pay it, and there are obviously some unfortunate circumstances where someone doesn't meet the exception for Crown employees, but are nevertheless required to be posted abroad. But you can get it back, but only if you meet this test within a particular period after completion.
Right.
It may be possible that you can change your plans, or your plans envisage you getting up to 183 within the particular period that's permitted. So it's not all lost. But yeah, it's entirely dependent on day counting.
Yeah. Yeah, on the whole, but we love day counting here, so yeah, I hear you. That's great. No, thank you. Right, a couple more then I think, and then we'll call it a day. So this one's quite interesting. We talked a lot about sort of reclaim firms, and we're not here dissing people, but there has been, as you say, a sort of, and I think the sense that the few spoil it for the many, really, that there have been a lot of firms out there sort of putting reclaims in for all sorts of things, whether it was MDR, derelict properties, mixed use, whatever. But this one relates to derelict property. I think the principles apply across the board. So people who have active people who've successfully reclaimed stamp duty on derelict properties, are they now at risk of paying the stamp duty back to HMRC? So I think we've seen the direction of travel from HMRC, and them getting perhaps less tolerant, for want of a better word. What's your view on that, Sean? Do you think that is a risk?
Yeah, so I mean, how reclaims work is that generally the revenue give effect to them, because all you're doing is changing your self-assessment. So repaying the tax isn't an indication that the revenue are happy that your self-assessment is correct, your amended
Yeah.
self-assessment is correct. So there may be risk or jeopardy for people who have received repayments, thinking that they've been successful, thinking that the arguments have been accepted by the revenue. Perhaps the success fees have been paid to the reclaim firm, and yet still the revenue may be in time to come back and say we disagree.
Right. Yeah, it is a risk, and yeah, so tread carefully. Okay, no. Well, that's useful to know. I'm not trying to scare people, but people need to be aware of these things, don't they? That's great. Thanks. A couple more here. So I've heard that a flat lease with the right to use a communal garden is mixed use. Is that right? Is that true?
Yes, I think your reaction, Angela, probably is the answer, which is someone is buying a flat they're buying a flat, and the fact that
Yeah.
the lease may have some type of permission, which might be a license or an easement or something else, to access, let's say, a communal garden, or it might be some other type of communal facility, doesn't make it non-residential. It's a flat. So arguments have been made that rights to use a communal garden in particular do make a flat purchase non-residential mixed use. Those arguments have been unsuccessful,
Mm.
unsurprisingly, at the tribunal on at least 3 occasions, and I think there are more cases expected this year. So that's one of these occasions when it's definitely too good to be true, and I would be very cautious of accepting that argument.
Yeah, no, makes sense to me. Thank you. So we'll just do one more and then we'll close. So I think, I mean, I've kind of gone in the direction of travel. There's a question here saying, is there likely to be more SDLT case law this year? I imagine the answer is yes, but you know, where do you, and for that crystal ball gazing, where do you think this may end, if you like, or what do you think is coming?
Yeah, so it's a good question. So I think MDR cases naturally will start to end as you know, the time limit for reclaiming the tax has ended, and you know, I'm not anticipating many, you know, cases regarding what is a single dwelling in the context of a 6 or more rule, or higher rates necessarily. So I think MDR cases or MDR appeals will die down this year probably, but the mixed use rule is still here. Naturally, people are still buying properties with lots of grounds. Inevitably, for obvious reasons, people might allow a farmer to graze their livestock on this land because it's not needed, and it's quite pleasant to see some sheep or cows on the land. So these facts are not contrived, and uh, in many cases they are legitimate arguments, but they're certainly not certain arguments. Derelict dwellings and dwellings which are being sold, partially demolished, or at shell and core stage, I suspect will be the subject of more appeal, or the first appeals of their type. Maybe not this year, but certainly next year. So I do think we're looking at probably another 2 or 3 years at least of cases being heard, which might illuminate some more issues regarding all of this.
Before it settles a bit, hopefully.
Yeah.
Thanks for that. We have just had one more, so I'll just try and squeeze this in very quickly and then we will call it a day, and just want to flick onto the next slide about the next webinar as well. But so I've inherited a land parcel, can't be accessed, which is part of a garden to a residential property owned by someone else. So I think I follow that. So land through a resi property owned by someone else. Could the ownership of the land expose me to an additional SDLT charge on buying a new main residence? It's very fact specific there, but what do you think about that one, Sean?
No, so in order to engage the surcharge for buying an additional dwelling, you need to own a dwelling. And even if this land is residential, because it's, you know, grounds of a dwelling, even if it were, it doesn't include that dwelling on the land. So the gateway into the higher rates, I don't think will be met simply by virtue of the fact all you're doing is buying effectively garden land. But that doesn't mean to say it's non-residential. It just means to say that it will be taxed at the standard rates when you buy it. I think in this particular case, it was inherited. But what it does mean is it won't engage the higher rates when they come to buy their new dwelling.
Okay. Yeah, makes sense. Thank you. Brilliant. Thank you very
Thank
much for that,
you.
Sean. Would you mind just flicking on the slide? I think I seem to have,
Of course.
I'm supposed to have dual control, but just so we can talk about the next webinar briefly. But obviously, thank you for there should be a slide there. So yeah. So firstly, Sean, thanks very much for today. Hopefully, all of our attendees have found that really interesting. I certainly have. I think SDLT is a minefield, always has been, and increasingly is more still. So you know, yeah. If you've got any further questions, those attending, and then please do reach out to Sean or through myself, or whatever, and we will, you know, respond to those hopefully. And clearly, if there's advice needed, then please do get in touch. Next webinar for us is on the 27th of February, which is hot tax topics, share valuations. So, but it is a hot topic. I think we're seeing more and more clients moving towards an exit, and not just with exit, but awarding shares to employees and needing to value their businesses as a result of that. So that's on the 27th of February, between 10 and 10:30. And yeah, thanks very much for attending. I think there's one more slide, Sean, which I think is just a thank you. Sorry to get you to do my dirty work. There you go. I think there you go. So thank you for attending, and thanks very much, Sean, and thank you everybody. See you next time. Thanks, Sean.
Pleasure.
Thanks. Bye.